You want to understand Indian polity, but you're short on time, maybe feeling a bit overwhelmed by the detail. I totally get it.
Uh-huh.
That's why we're doing this deep dive into M. Laxmikant's Indian polity. Think of it as your fast track to getting informed.
Exactly. We're pulling out the key nuggets, the
Mhm.
crucial information, so you can grasp the core concepts, well, quickly and thoroughly.
And it's a hefty book, isn't it? Covers everything from the constitutional framework, how the government works at union and state levels, loads of institutions.
It really does. So, obviously, we can't cover every single page today.
No, definitely not.
But the idea is to synthesize information from different parts, give you a cohesive picture of certain key aspects.
So the mission today.
Basically, to illuminate some core parts of the Indian political system, focusing on maybe some surprising facts, connections, seeing how it all fits together based on these excerpts.
Okay, let's get started. Where better to begin than the historical context? To really get the system now, we need to see how it came to be.
Absolutely. You have to look back. The story really begins with the company rule, that's 1773 to 1858,
All right.
followed by the crown rule, 1858 right up to 1947. These periods really laid the groundwork for a lot of the structures we still see.
And within that company rule, you had these key laws, the Charter Acts.
Yes, the Charter Acts. And what's interesting is how they incrementally shifted things.
Oh, so?
Well, take the Charter Acts of 1813 and 1833. The 1813 one, for instance, ended the East India Company's trade monopoly, mostly, except for tea and the China trade initially. But it opened India up to other British merchants. Crucially, it also asserted British sovereignty more strongly and allowed Christian missionaries in, influencing Western education.
So that's a shift from just trade to more direct control and influence.
Definitely. It's kind of the moment Britain really pivots from just a trading entity to a full-on political power in India, opening the floodgates, you could say.
And the 1833 Act.
That really pushed towards centralization, consolidated British power further.
Okay, fast forward a bit. The Government of India Act of 1935. This feels significant, being so close to independence.
It absolutely was
Yeah.
hugely influential. It introduced bicameralism to legislative houses in some provinces,
Okay.
and it continued things like communal representation. This act actually served as a major blueprint for parts of the independent Indian constitution later on.
Right. Makes sense. So then we hit the big one, the Indian Independence Act of 1947.
This is it. End of British paramountcy. The princely states were suddenly free to choose join India, Pakistan, or, theoretically, remain independent.
And how was the country run right at the start?
Well, initially, the Government of India Act of 1935 continued to govern the new dominions, India and Pakistan, until they framed their own constitutions.
Wow, that's quite a journey just to get to independence. So how did we get the constitution we have today?
The crucial next step was forming the Constituent Assembly. You had key figures, absolute giants, like Dr. B.R. Ambedkar.
Often called the father of the Constitution.
And modern Manu, yes. His role was immense, especially chairing the drafting committee.
Navigating all those different interests must have been incredibly tough.
Absolutely crucial work. You also had the Experts Committee of the Congress, chaired by Jawaharlal Nehru, contributing significantly.
And the assembly itself.
Initially, 296 members representing various communities. It was designed to be diverse.
That diversity seems key.
Essential, really, to try and ensure the Constitution reflected the whole nation. So the Constitution they adopted, November 26, 1949.
The day we celebrate as Constitution Day now.
Exactly. It had a preamble, 395 articles, and 8 schedules back then.
And that interesting detail, the preamble was actually enacted last.
Yes, precisely to make sure it aligned perfectly with the body of the Constitution that had been debated and finalized.
Okay, so that sets the historical stage. Now let's pivot to the fundamental principles. What are the sort of bedrock ideas?
Well, first off, you have this idea of a federal system, but with a unitary bias. India has features of a federation, 2 levels of government, center and states, a division of powers, a written constitution.
Okay, standard federal stuff.
But it also has strong unitary features, like a very strong central government, a single constitution for both center and states, single citizenship.
Ah, so it leans towards the center.
In many ways, yes. It's often described as quasi-federal, or as the book puts it, federal in form, but unitary in spirit. It's a unique blend.
A balancing act, maybe?
You could say that, and the emergency provisions really throw this into sharp relief.
Right, the 3 types.
Yes, national emergency under Article 352, state emergency or president's rule under Article 356, and financial emergency under Article 360.
And during these emergencies?
The whole system can tilt dramatically towards being unitary. The center gains extraordinary powers.
That's quite a significant power shift available.
It is, and it's meant for extraordinary circumstances, obviously, but it's a key feature. Now, another point often raised is the criticism that the Constitution is borrowed.
Yeah, you hear that sometimes. It's a patchwork.
But the counter-argument, and what the framers themselves emphasized, is that they didn't just copy-paste. They adapted features from many constitutions, UK, US, Ireland, Canada, others, but modified them extensively to fit India's specific conditions, its unique problems and needs.
Makes sense. You need it to work for India.
Precisely.
Yeah.
Then you have the preamble itself.
Yeah.
Hugely significant.
Setting out the core values.
Justice, liberty, equality, fraternity.
Mm.
And importantly, the Supreme Court has held it to be an integral part of the Constitution.
In which cases?
The Kesavananda case, famously, and also the LIC of India case. It's not just an introduction. It's seen as a guide, a philosophical key to the Constitution.
Okay, so principles established. Let's look at the actual structure, the union and its territory.
Right. Article 1 is the starting point. It describes India, that is Bharat, as a union of states.
Union of states, not federation of states.
Exactly. And crucially, Parliament has the power to form new states, alter boundaries, change names of existing states.
And does it need the state's permission?
No, that's the key bit. Parliament can do this without the consent of the state concerned. This leads to that famous description. India is an indestructible union of destructible states.
An indestructible union of destructible states. That's a really powerful phrase.
It sums it up well. The union itself is permanent, but the state's boundaries are flexible, decided by Parliament.
Is there any exception to this power?
Well, interestingly, the Supreme Court has said that settling boundary disputes with other countries doesn't necessarily require a constitutional amendment under Article 368. That can sometimes be done by executive action if it doesn't involve ceding territory.
So a bit more flexibility for international borders.
In certain specific circumstances, yes. A great example of changing territory, though, is the 100th Constitutional Amendment Act in 2015.
Ah, the land swap with Bangladesh.
Exactly. It involved exchanging numerous enclaves. India transferred 111 enclaves to Bangladesh and received 51 from Bangladesh. It settled long-pending issues.
Must have been incredibly complex, diplomatically and administratively.
Hugely significant. And thinking about internal reorganization, you have the States Reorganization Act of 1956.
That was massive, right? Redrawing the internal map.
It was, based largely on the recommendations of the Fazl Ali Commission. It led to the creation of 14 states and 6 union territories, often along linguistic lines.
Like Andhra Pradesh?
Andhra Pradesh for Telugu speakers, Kerala for Malayalam speakers, yes. That act fundamentally reshaped India's internal political geography.
And then much more recently, the reorganization of Jammu and Kashmir in 2019.
Yes, the state of Jammu and Kashmir was bifurcated into 2 union territories, Jammu and Kashmir and Ladakh.
And Article 370.
Article 370, which gave it special status, was effectively made inoperative. So a major constitutional change there.
Okay, so we have the physical map. Now, who belongs to this union? Let's talk citizenship.
Right. At the very beginning, when the Constitution commenced on January 26, 1950, there were 4 categories of people who automatically became citizens.
Sure.
It was based on factors like domicile, essentially, your permanent home birth in India, parentage, residency for a certain period before commencement, and also provisions for those who migrated from Pakistan due to partition.
Sounds like it needed to cover a lot of complex situations from that time.
Absolutely. The rules, especially around migration from Pakistan, had different cutoff dates, like July 19, 1948, reflecting the realities of partition.
And how can citizenship be lost today?
There are basically 3 ways outlined in the Citizenship Act of 1955. Renunciation, which is voluntary giving it up. Termination, if you voluntarily acquire citizenship of another country. And deprivation.
Deprivation sounds serious.
It is. This is compulsory termination by the government, but only under specific grounds. Things like obtaining citizenship by fraud, showing disloyalty to the Constitution, unlawfully trading with an enemy during war, being imprisoned in any country for 2 years within 5 years of registration, or being ordinarily resident out of India for 7 years continuously.
Okay. You mentioned domicile earlier. How does that relate to rights?
It's an important concept. While Article 15 prohibits discrimination only on grounds of religion, race, caste, sex, or place of birth, the Constitution does allow Parliament to prescribe residence within a state, or UT, as a condition for certain public employment. Article 16. And states can sometimes provide preferential treatment for their residents in certain matters, like education fees, as long as it doesn't violate other fundamental rights. So residence matters, even though place of birth discrimination is barred.
Got it. What about people of Indian origin living abroad, the OCI cardholders?
Right, the Overseas Citizen of India cardholder scheme. It's not dual citizenship.
Okay.
OCI cardholders get benefits like a multiple entry, multi-purpose lifelong visa to visit India and exemption from police registration for long stays. But they don't have political rights like voting or holding constitutional office.
Are there restrictions on who can get OCI status?
Yes. Generally, individuals whose parents, grandparents, or great-grandparents were citizens of India are eligible unless they or their ancestors were ever citizens of Pakistan or Bangladesh.
Okay, that historical context again. So now we know who the citizens are. Let's get to the core guarantees the fundamental rights.
Yes, Part 3 of the Constitution. These are the basic rights guaranteed to all citizens, and some are available to non-citizens too. But a key thing to remember, they are not absolute.
Meaning they can be restricted.
Exactly. They are subject to reasonable restrictions imposed by the state on grounds mentioned in the Constitution itself, like public order, morality, security of the state, etc. The courts decide if a restriction is reasonable.
So the government can't just infringe on them arbitrarily.
No. And they are justiciable. You can go to court, specifically the high courts or the Supreme Court, to enforce them.
Can they ever be suspended?
Yes, during a national emergency. Most can be suspended.
But not all.
Crucially, Article 20, protection in respect of conviction for offenses, and Article 21, protection of life and personal liberty, remain enforceable even during an emergency.
Okay, that's a
And Article 19, which guarantees 6 freedoms like speech, assembly, movement, etc., can only be suspended during an emergency declared on grounds of war or external aggression, not armed rebellion.
Right. So what are the main categories of these rights?
You have the right to equality, Articles 14, 18, equality before law, prohibition of discrimination, equality of opportunity in public employment, abolition of untouchability, abolition of titles.
Untouchability, abolition, Article 17. Very specific.
Absolutely fundamental. Then the right to freedom, Articles 1922, the 6 freedoms under 19, protection against arbitrary arrest and detention, Article 22, and the crucial Article 21, right to life and personal liberty.
Article 21 has been interpreted very broadly by the courts, hasn't it?
Hugely. It now includes the right to dignity, privacy, clean environment, health, livelihood, shelter, and the right to education, which was later made a separate article.
We'll come back to that. What else?
Right against exploitation, Articles 23, 24, prohibits human trafficking, forced labor, child labor. Right to freedom of religion, Articles 25 to 28, freedom of conscience, practice, propagation, managing religious affairs, freedom from religious taxes, and instruction in state-funded institutions.
And minority rights.
Cultural and educational rights, Articles 29, 30, protection of the interests of minorities regarding their distinct language, script, culture, and the right to establish and administer educational institutions of their choice.
And finally, the one that makes them enforceable.
The right to constitutional remedies, Article 22. Dr. Ambedkar called this the heart and soul of the Constitution. It guarantees the right to move the Supreme Court directly for the enforcement of fundamental rights.
Okay. Now, you mentioned evolution. What about recent changes, like the EWS reservation?
Yes, the 103rd Amendment Act of 2019 introduced up to 10% reservation for economically weaker sections, EWS, in education and public employment.
This is separate from the existing reservations for SCs, STs, and OBCs.
Correct. It's based on economic criteria, family income below a certain threshold, asset ownership limits. It amended Articles 15 and 16.
And the right to education you mentioned.
That came via the 86th Amendment Act, 2002. It inserted Article 21A, making free and compulsory education a fundamental right for all children between 6 and 14 years old.
A landmark change.
Definitely. You also asked about Article 22 safeguards against arrest.
Yes, what are those?
It provides rights, like being informed of the grounds for arrest, consulting a legal practitioner, and being produced before a magistrate within 24 hours. But these safeguards are generally not available for preventive detention.
Preventive detention. That's always controversial.
It is. Article 22 allows for detention without trial for a limited period under specific laws, aiming to prevent someone from committing a future act prejudicial to state security or public order. There are safeguards, like review by an advisory board, but it remains a debated aspect.
And the writs under Article 32.
Right. The Supreme Court and high courts under Article 226 can issue 5 types of writs to enforce fundamental rights.
Can you quickly run through them?
Sure. Habeas corpus, literally to have the body, used against unlawful detention. Mandamus, we command, directs a public official or body to perform a duty. Prohibition stops a lower court or tribunal from exceeding its jurisdiction. Certiorari, to be certified, quashes an order of a lower court tribunal. And quo warranto, by what authority, challenges a person's claim to a public office.
So powerful tools for the judiciary.
Absolutely. They are key instruments for upholding rights. One more point. Article 34 allows Parliament to restrict fundamental rights while martial law is in force in any area.
Okay. Are there criticisms of the fundamental rights chapter?
Yes, some common ones include the complexity and expense of seeking remedies, making them less accessible to the poor, the extensive limitations and exceptions allowed, and, as mentioned, the provision for preventive detention, which many see as contrary to democratic principles.
Right. So alongside these enforceable rights, you have the directive principles of state policy, the DPSPs. How do they fit in?
DPSPs are in Part 4 of the Constitution. They're essentially guidelines or instructions for the state, both the union and state governments, when formulating policies and laws.
But they're different from fundamental rights because
They are non-justiciable. Article 37 explicitly says they shall not be enforceable by any court.
So if the government doesn't follow a DPSP, you can't sue them for it.
Correct. But Article 37 also says they are fundamental in the governance of the country, and it's the duty of the state to apply these principles in making laws.
So more like moral or political directives, aiming for what kind of state?
Exactly. They aim to establish a welfare state and promote socio-economic democracy, complementing the political democracy provided by fundamental rights.
Can you give some examples?
Sure. Article 39A calls for equal justice and free legal aid. Article 41 talks about securing the right to work, education, and public assistance in cases of unemployment, old age, sickness. Article 43A promotes worker participation in management. Article 48A directs the state to protect and improve the environment and safeguard forests and wildlife.
Environment protection as a directive back then, quite forward-looking.
Use added by the 42nd Amendment, but yes. And Article 51 aims to promote international peace and security.
Okay. Now, what about the relationship or conflict between fundamental rights, justiciable, and DPSPs, non-justiciable?
That's been a major theme in constitutional law. Initially, fundamental rights were seen as superior. Then, the 42nd Amendment, 1976, tried to give primacy to all DPSPs over certain fundamental rights, Articles 14, 1931.
But that didn't stick?
No. The Supreme Court, in the Minerva Mills case, 1980, struck down this blanket primacy. It held that the harmony and balance between FRs and DPSPs is a basic feature of the Constitution. Parliament can amend FRs to implement DPSPs, but not in a way that destroys the basic structure.
So back to balance.
Yes. Though, importantly, the court upheld the validity of Article 31C as it stood before the 42nd Amendment, meaning laws implementing DPSPs under Article 39B and C, related to equitable distribution of resources and preventing concentration of wealth, can be protected from challenge under Articles 14 and 19.
Right. Have DPSPs actually been implemented?
Yes. Many policies and laws reflect DPSPs. Things like land reforms, minimum wage laws, the establishment of the Planning Commission, now NITI-IOG, promotion of cottage industries, maternity benefit laws, free legal aid schemes, environmental protection laws. They all draw inspiration from DPSPs.
What about language? Are there directives on that?
Yes, Article 350A directs states to provide facilities for instruction in the mother tongue at the primary stage for linguistic minorities. And Article 351 imposes a duty on the union to promote the spread and development of the Hindi language.
Like the fundamental rights, are there criticisms of DPSPs?
Certainly. The main one is their non-justiciable nature. Some call them pious declarations or aspirations. Others point to a lack of clarity in some directives or argue they represent a conservative or outdated social philosophy in some aspects. Some even call them a code of moral precepts.
Okay, so rights, directives, and then fundamental duties. These came later.
Yes, much later. Added by the 42nd Amendment in 1976, based on the Swaran Singh Committee recommendations. They're in Part 4A, under Article 51A.
And the idea was?
To remind citizens that while they have rights, they also have duties towards the nation and society.
What kind of duties?
There are 11 now. One was added later. They include things like abiding by the Constitution and respecting its ideals and institutions, the national flag and anthem, cherishing the ideals of the freedom struggle, upholding sovereignty, unity, and integrity of India, promoting harmony and brotherhood, valuing our composite culture, protecting the environment, developing scientific temper, safeguarding public property, striving for excellence.
So quite a broad range of civic and moral obligations.
Yes. And like DPSPs, they are also non-justiciable. Courts can't directly enforce them.
So, again, criticism focuses on that.
Yes, non-justiciability is a key criticism. Others argue some duties are vague, or that they are superfluous as they should be inherent in being a citizen. Some also feel their placement as an appendage after Part 4 reduces their value.
Right. So, we have this complex structure. How can the Constitution itself be changed? The amendment process.
That's primarily governed by Article 368 in Part XX. It lays out the power of Parliament to amend the Constitution and the procedure for it.
Is it easy to amend?
It's a mix. The Indian Constitution is described as partly rigid and partly flexible. Some provisions can be amended by a simple majority in Parliament, like ordinary laws, though these are technically not considered amendments under Article 368. Examples include formation of new states or changes to citizenship rules.
Okay, that's the flexible part.
Then, most provisions require a special majority in Parliament.
Which is?
A majority of the total membership of each house, and a majority of 2/3 of the members present and voting in each house.
That's a higher bar.
Definitely. And then, for certain provisions related to the federal structure, like the election of the president, extent of executive power of union states, Supreme Court, high courts, distribution of legislative powers, or Article 368 itself, there's a third layer.
Which requires
Amendment by that special majority in Parliament, plus ratification by the legislatures of at least half of the states by a simple majority. This is the rigid part.
So, three different ways, essentially. What about the president's role?
Originally, there was ambiguity. But the 24th Amendment Act, 1971, made it obligatory for the president to give assent to a constitutional amendment bill when it's presented after passing Parliament.
So the president can't veto an amendment.
Correct. This blend of flexibility and rigidity was intentional. Casey Ware called it a unique blend, while Nehru felt it struck a good balance, avoiding excessive rigidity while guarding against too easy changes.
But Parliament's power to amend isn't unlimited, right? The basic structure doctrine.
Exactly. This is crucial. Despite Article 368 seemingly giving wide powers, the Supreme Court, most famously in the case of Anna Dovrati case, 1973, ruled that Parliament cannot amend the Constitution in a way that alters its basic structure or fundamental features.
So even with the correct procedure, some things are off limits.
Yes. Parliament can amend any part, including fundamental rights, but cannot destroy the core identity or foundation of the Constitution.
What constitutes the basic structure? Has the court defined it?
It hasn't given an exhaustive list, but through various judgments, elements identified as part of the basic structure include supremacy of the Constitution, sovereign democratic republic in nature, secular character, separation of powers between legislature, executive, and judiciary, the federal character, unity and integrity of the nation, judicial review, rule of law, harmony between FRs and DPSPs, parliamentary system, principle of free and fair elections, independence of judiciary.
So quite a few core principles.
Yes, it acts as a fundamental check on Parliament's amending power.
Okay, now let's talk about the system of government itself. India chose a parliamentary system.
Yes, adopted largely from the British model, often called the Westminster model. It's characterized by cooperation and coordination between the legislative and executive organs.
As opposed to.
The presidential system, like in the USA, which is based on a stricter separation of powers.
Key features of the Indian parliamentary system.
Presence of nominal president and real prime minister executives. Majority party rule. Collective responsibility of the executive, council of ministers, to the legislature, specifically Lok Sabha. Membership of ministers in the legislature. Leadership of the prime minister. And the dissolution of the lower house, Lok Sabha.
What are seen as the merits of this system?
Harmony between legislature and executive, responsible government, ministers accountable to parliament, prevents despotism, power dispersed, and allows for wide representation.
And the potential demerits.
Can lead to unstable governments if no clear majority or coalitions break down, lack of continuity in policies if governments change frequently, potential for a dictatorship of the cabinet if the ruling party has a large majority, and ministers might be amateurs in administration, chosen more for political reasons.
So why did India choose this system over the presidential one?
Several reasons cited. Familiarity with the system from British rule, preference for responsibility, accountability to legislature, over stability, fixed executive term, need to avoid conflict between legislature and executive, which might have occurred in a new democracy, and the need to accommodate the diversity of India through broader representation in the executive drawn from parliament.
Makes sense in that context. Now, within this system, let's look at federal relations, the center-state dynamic.
As we said, India is federal with a strong center. The Constitution divides legislative powers very clearly.
The three lists.
Yes. The Union List, List 1, has subjects where only Parliament can make laws, defense, foreign affairs, currency, banking, railways, etc., currently around 100 subjects.
Okay.
The State List, List 2, has subjects for state legislatures, public order, police, public health, agriculture, local government, etc., around 61 subjects now.
And the third?
The Concurrent List, List 3. Both Parliament and state legislatures can make laws here: criminal law, marriage, divorce, education, forests, trade unions, electricity, etc. Around 52 subjects.
What happens if both make a law on a concurrent subject and they conflict?
Generally, the union law prevails over the state law.
And what about subjects not mentioned in any list? Residuary powers.
Unlike the U.S. or Australia, where they rest with states, in India, residuary powers belong exclusively to the Union Parliament. This again shows the centralizing tendency.
Does Parliament ever legislate on the state list?
Yes, under 5 extraordinary circumstances. 1. If Rajya Sabha passes a resolution by a 2/3 majority in the national interest, Article 249. 2. During a national emergency, Article 250. 3. If 2 or more states request Parliament to do so, Article 252. 4. To implement international treaties or agreements, Article 253. 5. During President's rule in a state, Article 356.
So several ways the center can step into the state domain. What about administrative relations?
The center's executive power generally extends to matters on the Union list and states on the state list, but the state's executive power must be exercised in compliance with union laws.
Can the center give directions to states?
Yes. The Constitution empowers the center to give directions to states in certain matters, like construction of communication lines, protection of railways, ensuring compliance with union laws. Non-compliance can even be a ground for imposing President's rule, Article 365.
That's a strong lever. What about things like the All India services, IAS, IPS, IFS?
They are recruited and trained by the center, but serve in both center and state cadres. They are seen as instruments of union control and ensuring uniform administrative standards across the country. This integrated system is unique to India.
Okay. Financial relations. How is money divided?
This is complex. The Constitution lays down an elaborate scheme for distributing tax revenues. Some taxes are levied by the center but collected and kept by the states, like stamp duties under Article 268.
Others?
Some taxes are levied and collected by the center but assigned to the states, like taxes on interstate trade under GST regime, Article 269A. Then there are taxes levied and collected by the center but distributed between the center and states, like income tax, union excise duties, now subsumed under GST, largely Article 270.
And how is this distribution decided?
Primarily based on the recommendations of the Finance Commission, a constitutional body appointed every 5 years, Article 280. The center also provides grants and aid to states, both statutory grants, Article 275 via Finance Commission, and discretionary grants, Article 282.
What about GST? That changed things significantly.
Hugely. The Goods and Services Tax, GST, introduced by the 101st Amendment Act, subsumed many indirect taxes. The GST Council, a constitutional body with representatives from center and all states, makes recommendations on tax rates, exemptions, threshold limits, etc. It's meant to be an example of cooperative federalism.
Have there been commissions specifically to look at center-state relations?
Yes, major ones include the Sarkaria Commission, 1983-88, and the Punchy Commission, 2007-10. They made numerous recommendations on legislative, administrative, and financial relations, the role of governors, use of Article 356, interstate council, etc., aiming to improve cooperation and reduce friction.
And the Interstate Council.
Provided for under Article 263, it's a forum for discussion between states and between the center and states to promote coordination and cooperation. The Sarkaria Commission recommended revitalizing it.
So a constant process of managing this complex relationship.
Absolutely. Now let's revisit those emergency provisions in a bit more detail.
Right, the 3 types again. National, state, financial. Grounds for national emergency, Article 352.
War, external aggression, or armed rebellion. Note, armed rebellion replaced internal disturbance via the 44th Amendment to prevent misuse like in 1975.
And how is it proclaimed?
By the President, but only on the written recommendation of the Union Cabinet. It must be approved by both houses of Parliament within 1 month by a special majority. It can continue for 6 months at a time, extendable indefinitely with parliamentary approval every 6 months. Center gets power to give executive directions to any state on any matter. Parliament can make laws on subjects in the state list. The president can modify the distribution of revenues, and fundamental rights under Article 19 are automatically suspended if emergency is due to external aggression, while others can be suspended by presidential order, except Articles 20 and 21.
Okay. Now, state emergency or president's rule, Article 356.
This can be proclaimed if the president, usually on a report from the governor, is satisfied that the government of a state cannot be carried on in accordance with the Constitution. Article 365 also allows it if a state fails to comply with central directions.
Approval needed.
Yes, by both houses of parliament within 2 months by a simple majority. It initially lasts for 6 months, extendable up to a maximum of 3 years with parliamentary approval every 6 months, with some conditions after 1 year.
Consequences.
The president can assume functions of the state government, dismiss the state council of ministers, declare that powers of the state legislature are exercisable by parliament, and suspend constitutional provisions relating to any state body except the High Court. The state assembly might be suspended or dissolved.
This one has been quite controversial, right? Accusations of misuse.
Very much so. The Sarkaria and Punchy commissions and Supreme Court judgments, like S.R. Baumai case, have laid down safeguards and guidelines suggesting it should be used sparingly, as a last resort, only in cases of actual breakdown of constitutional machinery.
When was it first used?
Punjab, 1951. It's been used over 100 times since. Famously used to dismiss opposition state governments en masse in 1977 and 1980 after changes at the center.
And financial emergency, Article 360.
If the president is satisfied that the financial stability or credit of India or any part is threatened, needs parliamentary approval within 2 months, allows center to give financial directions to states, president can order reduction of salaries of union state employees, including judges.
Has this ever been used?
No, never proclaimed so far.
Okay, that covers the emergency framework. Let's shift to the people running the show at the union level, the union executive. Who's included?
The Constitution lists the president, vice president, prime minister, council of ministers, and the attorney general of India as comprising the union executive.
Let's start with the president, head of state, but indirectly elected.
Yes. Elected by an electoral college consisting of 1. Elected members of both houses of parliament, MPs, and 2. Elected members of the legislative assemblies of the states, MLAs.
Who does not vote?
Nominated members of parliament and state assemblies, and members of state legislative councils, if the state has one.
And the voting system?
Proportional representation by means of the single transferable vote and secret ballot. The system aims to ensure uniformity in the scale of representation of different states and parity between the states as a whole and the union.
Okay. Powers of the president. Executive powers.
Huge list. All executive actions of the government of India are formally taken in his name. He appoints the prime minister and other ministers on PM's advice, attorney general, comptroller and auditor general, KEGI, chief election commissioner and other election commissioners, chairman and members of UPSC, governors of states, chairman and members of finance commission, etc. He makes rules for transaction of government business.
Quite the appointing authority. Legislative powers.
Integral part of parliament. Summons and prorogues both houses, dissolves Lok Sabha, addresses parliament at start of first session after election and each year, sends messages to parliament, appoints speaker pro tem, nominates members to Lok Sabha, Anglo-Indians, now discontinued, and Rajya Sabha, 12 members with special knowledge experience, lays reports of CAG, UPSC, Finance Commission, etc. before Parliament. And crucially, the ordinance-making power under Article 123.
Ordinance is temporary laws when Parliament isn't sitting.
Exactly. They have the same force as an act of Parliament, but must be approved by Parliament within 6 weeks of its reassembly, otherwise they lapse. The power is subject to limitations, can only be on subjects Parliament can legislate on, and subject to same constitutional limits as acts. The Supreme Court, D.C. Wadhwa case, ruled against excessive repromulgation without placing them before the legislature.
Okay. Other powers, briefly.
Financial powers. Money bills need prior recommendation, lays budget, controls contingency fund. Judicial powers, appoints judges of SCHCs, can seek advisory opinion from SC Article 143 and the pardoning power Article 72.
Pardoning power.
Can grant pardon, reprieve, respite, remission, or commute sentences for offenses against union laws, court-martial sentences, and death sentences.
And diplomatic military emergency powers.
Represents India internationally, appoints, receives diplomats, Supreme Commander of Defense Forces, and proclaims emergencies, as we discussed.
All right. Now the vice president.
Also indirectly elected by an electoral college consisting of all members, elected and nominated, of both houses of parliament. State legislatures are not involved.
System of election.
Same. Proportional representation by single transferable vote, secret ballot,
Main function?
Ex officio chairman of the Rajya Sabha, presides over its proceedings, acts as president when there's a vacancy due to death, resignation, removal, or otherwise for a maximum of 6 months,
Term of office.
5 years. Can be removed by a resolution of Rajya Sabha passed by an effective majority of total membership then, and agreed to by Lok Sabha by a simple majority. Needs 14 days notice.
Okay. Next, the real engine room. The Prime Minister and the Central Council of Ministers.
Right. Article 74 says there shall be a council of ministers, with the PM at the head to aid and advise the president. The president shall act in accordance with such advice.
Can the president ask for reconsideration?
Yes, the president may require the COM to reconsider the advice, but is bound by the advice tendered after reconsideration. And crucially, the advice tendered cannot be inquired into by any court.
Confidentiality there. How are they appointed?
The president appoints the PM, usually the leader of the majority party or a coalition, in Lok Sabha. Other ministers are appointed by the president on the advice of the PM.
And their responsibility.
Article 75 lays down key principles. Ministers hold office during the pleasure of the president, effectively meaning pleasure of the PM confidence of Lok Sabha. The Council of Ministers is collectively responsible to the Lok Sabha.
Collective responsibility, the bedrock.
Yes. Means they swim or sink together. If a no-confidence motion is passed against the government in Lok Sabha, the entire COM must resign. There's also individual responsibility. Minister holds office at president's pleasure, but no legal responsibility in India for acts of state signed by ministers, unlike UK. A minister must be or become a member of either House of Parliament within 6 months.
What are the different ranks of ministers?
Typically 3 categories. Cabinet ministers, head important ministries, form the cabinet, the core policy-making body. Ministers of state can be given independent charge or attached to cabinet ministers, and deputy ministers assist cabinet ministers or MOAS.
And the PM's role is central.
Absolutely. Head of government, leader of the COM, link between president and COM, leader of the ruling party, chief spokesperson. Recommends appointments, allocates portfolios, presides over cabinet, coordinates ministries, advises president on summoning, proroguing parliament, dissolution of Lok Sabha.
You sometimes hear about a kitchen cabinet.
Yes, an informal body smaller than the cabinet consisting of the PM and maybe 2 or very trusted senior colleagues. It's seen as the real center of power, taking important decisions quickly.
And there are formal cabinet committees too.
Yes, set up by the PM to reduce the cabinet's workload. Important ones include the Political Affairs Committee, often called Super Cabinet, Economic Affairs Committee, Appointments Committee of the Cabinet, ACC, Parliamentary Affairs Committee.
Okay, that covers the executive. Let's move to the legislature parliament, Lok Sabha and Rajya Sabha.
Right. Parliament consists of the President, the Council of States, Rajya Sabha, and the House of the People, Lok Sabha.
Rajya Sabha, the upper house.
Represents the states and UTs. Members are elected indirectly by the elected members of state legislative assemblies. Proportional representation by single transferable vote. Plus 12 members nominated by the President. Max strength 250. It's a continuous body, not subject to dissolution. 1/3 retire every 2 years.
Lok Sabha, the lower house.
Represents the people directly. Members elected by universal adult franchise from territorial constituencies. Max strength 550, 530 states plus 20 UTs. Normal term is 5 years, but can be dissolved earlier by the president.
Qualifications for being an MP.
Must be citizen of India, take an oath, be at least 30 years old for Rajya Sabha, 25 for Lok Sabha, and possess other qualifications prescribed by Parliament, like being registered voter.
Disqualification.
Holding an office of profit under union state government, exceptions exist. Being of unsound mind. Being an undischarged insolvent. Not being a citizen or having acquired foreign citizenship. Being disqualified under any law made by Parliament, like the Representation of the People Act, 1951, for electoral offense corruption.
Right.
And crucially, disqualification on ground of defection under the 10th schedule.
Ah, the anti-defection law. Who decides on disqualification?
For grounds other than defection, the president decides after obtaining the election commission's opinion. For defection, the presiding officer of the House, Speaker Chairman, decides. Their decision was initially final, but is now subject to judicial review. Quixote Hallheim case.
How can an MP lose their seat? Vacating seats.
Several ways. Dual membership, can't be member of both houses or parliament and state legislature simultaneously. Resignation, absence, if absent from all meetings for 60 days without permission, if disqualified after election, or if their election is declared void by a court.
Who runs the houses? The presiding officers.
Yes. Lok Sabha has the Speaker and Deputy Speaker, elected by the House from amongst its members. Rajya Sabha has the chairman, vice president indi ex officio, and deputy chairman, elected by Rajya Sabha members.
The speaker's role is quite powerful.
Very. Presides over sittings, maintains order, interprets rules, adjourns, suspends House, certifies money bills, decides defection questions, chairs key committees. The first speaker was G.V. Mavalankar. The speaker usually remains in office even if Lok Sabha dissolves, until the first meeting of the new Lok Sabha.
Okay. Parliamentary proceedings, some key terms. Summoning, prorogation, dissolution.
President summons each House to meet. Prorogation, also by President, terminates a session, not the House itself. Dissolution ends the life of the Lok Sabha, requiring fresh elections. Rajya Sabha isn't dissolved.
Adjournment.
Suspends the work in a sitting for a specified time, hours, days, weeks. Done by the presiding officer. Adjournment sine die means terminating a sitting indefinitely, also by the presiding officer. Prorogation usually follows adjournment sine die.
Who can speak in the House?
Members, obviously. Also, ministers and the Attorney General have the right to speak and take part in proceedings of either House, joint sittings, and committees they're named to. But they can only vote in the House they are a member of.
Now, the core function. How does a bill become law? Legislative procedure.
A bill goes through several stages in each House. First reading is just the introduction and publication. Second reading is the crucial stage, general discussion of principles, then detailed clause-by-clause consideration, often after reference to a committee. Amendments are moved and voted on. Third reading is debate confined to acceptance or rejection of the bill as a whole.
And if one House passes it?
It goes to the other House, which repeats the process. If the second House passes it without amendments, or with amendments the first House agrees to, it goes to the President for assent.
What if the second House rejects it or proposes amendments the first House dislikes or takes no action for 6 months?
That's a deadlock. The President can summon a joint sitting of both Houses, Article 108, to resolve it. The bill is passed if supported by a majority of total members present and voting in the joint sitting. Lok Sabha usually prevails due to its larger size. Joint sittings don't apply to money bills or constitutional amendment bills.
Okay. Special procedure for money bills.
Yes. Defined in Article 110, deals with taxes, government borrowing, consolidated fund, etc. Speaker certifies if a bill is a money bill. Can only be introduced in Lok Sabha and only on President's recommendation.
Rajya Sabha's role.
Very limited. After Lok Sabha passes it, Rajya Sabha receives it. It has 14 days to return it, with or without recommendations. Lok Sabha can accept or reject Rajya Sabha's recommendations. If Rajya Sabha doesn't return it in 14 days, it's deemed passed by both houses.
So Lok Sabha has clear financial supremacy. What about financial bills, different from money bills?
Yes. Financial bills also deal with fiscal matters, but are broader. Financial bills, under Article 117.1.1, contain money matters, but also other provisions. Like money bills, they need President's recommendation and can only be introduced in Lok Sabha. But otherwise, the legislative process is similar to ordinary bills, including Rajya Sabha's power to amend, reject, and the possibility of a joint sitting.
And financial bills, too.
Under Article 117.3, these involve expenditure from the consolidated fund, but don't solely contain matters listed in Article 110 money bill definition. They don't need prior recommendation for introduction and can be introduced in either House. But they need President's recommendation for consideration if they involve expenditure. Process is like ordinary bills.
Okay, complex distinctions. What about the budget process?
The annual financial statement, Article 112, presented to Parliament usually in February, involves several stages: presentation, general discussion, scrutiny by departmental committees, they examine demands for grants ministry-wise, voting on demands for grants, exclusively Lok Sabha power, Rajya Sabha only discusses, passing of appropriation bill, authorizes withdrawal from consolidated fund, passing a finance bill, gives effect to government's financial proposals for next year.
What's a vote on account?
Since the budget process takes time, Parliament passes a vote on account, usually for 2 months, authorizing the government to draw funds from the consolidated fund for its expenses until the appropriation bill is passed. It only covers expenditure, not receipts.
Got it. What are the overall powers and functions of Parliament?
Legislative, making laws on union concurrent lists, residuary subjects, even state lists sometimes. Executive control, through questions, motions, no confidence. Financial, control over taxation and expenditure via budget. Constituent mending constitution. Judicial, impeachment of president. Removal of VP, judges, CEC. electoral, elects president VP, and other functions like discussing issues, approving emergencies, creating abolishing state legislative councils.
Does Rajya Sabha have any special powers not shared with Lok Sabha?
Yes, 3 exclusive powers. 1, authorizing Parliament to make law on a stateless subject, Article 249. 2, authorizing Parliament to create new All India services, Article 312. 3, initiating the removal of the Vice President, Article 67. These reflect its role as representative of states.
What about parliamentary privileges? What are they?
Special rights, immunities, and exemptions enjoyed by the Houses of Parliament, their committees, and their members, individually and collectively, designed to secure independence and effectiveness.
Where do they come from?
Sources include constitutional provisions, Article 105, laws made by Parliament, rules of procedure of the Houses, parliamentary conventions, and judicial interpretations. Key privileges include freedom of speech within Parliament, immunity from court proceedings for anything said or voted, freedom from arrest in civil cases during session, right to exclude strangers, punish for breach of privilege contempt.
Is Parliament sovereign in India like in the UK?
No. Unlike the UK's doctrine of parliamentary sovereignty, India has constitutional supremacy. Parliament's powers are limited by the written constitution, the federal system, fundamental rights, and the power of judicial review.
Let's talk about parliamentary committees. Why are they needed?
Parliament deals with complex and voluminous business. Committees help scrutinize legislation, government finances, policies, and administration in detail, enabling more informed parliamentary oversight.
What types are there?
Broadly, 2, standing committees, permanent, constituted yearly, and ad hoc committees, temporary for specific tasks, cease when task is done.
Examples of important standing committees. Financial ones.
3 key financial committees. 1, Public Accounts Committee, PAC, examines CAG audit reports on government spending, oldest committee. 2, Estimates Committee examines budget estimates, suggests economy measures, largest committee. 3, Committee on Public Undertakings, COPU, examines reports and accounts of public sector enterprises.
Other standing committees?
Yeah, many others. Departmental standing committees, 24 of them, cover all ministries, examine demands for grants, bills, policies. Committees to inquire, petitions, privileges, ethics. Committees to scrutinize and control, government assurances, subordinate legislation, papers laid on table, SCST welfare. Committees relating to day-to-day business, business advisory, private members' bills. Housekeeping committees, general purposes, House Library, Joint Committee on Salaries.
What about consultative committees?
Attached to various ministries. Include MPs from both houses, provide a forum for informal discussion between ministers and MPs on ministry policies working. Membership is voluntary.
And parliamentary forums, what are they?
Relatively new concept. Started in 2005. Provide a platform for MPs to interact with ministers, experts, and officials on critical issues, sensitizing them and enabling informed debate.
What topics do they cover?
Forums exist on water conservation, youth, children, population and public health, global warming and climate change, disaster management, artisans and craftspeople, Millennium Development Goals.
And the Indian Parliamentary Group, IPG.
This is the autonomous body that serves as the link between the Parliament of India and various parliaments of the world, primarily through membership in the Interparliamentary Union, IPU, and the Commonwealth Parliamentary Association, CPA.
What does membership offer MPs?
Opportunities for contacts, understanding parliamentary practices elsewhere, participating in international conferences, promoting goodwill.
Okay, extensive coverage of Parliament. Let's switch to the third pillar, the judiciary, starting with the Supreme Court.
Right. India has an integrated judicial system, unlike the U.S. dual system.
Yeah.
The Supreme Court is at the apex, followed by high courts at the state level, and then subordinate courts.
Supreme Court composition.
Chief Justice of India, CJI, and other judges.
Yeah?
Number determined by Parliament. Currently CJI plus 33 judges, appointed by the President.
How are they appointed? The collegium system.
Yes. Judges, including CJI, are appointed by the President after consultation with judges of the Supreme Court and high courts as deemed necessary. For appointing judges other than CJI, the CJI must be consulted. The consultation has been interpreted by the SC through the 3 judges' cases to mean concurrence of a collegium.
What is the collegium?
For SC appointments, it's the CJI plus the 4 senior-most SC judges. For HC appointments, it involves the CJI, 2 senior-most SC judges, and consultation with the HC Chief Justice and collegium.
Wasn't there an attempt to change this, the NJHD?
Yes, the 99th Amendment Act and the NJC Act 2014 tried to replace the collegium with a National Judicial Appointments Commission, NJAC, comprising the CJI, 2 senior SC judges, the law minister, and 2 eminent persons. However, the Supreme Court declared both the amendment and the act unconstitutional in 2015, holding that they violated the independence of the judiciary, a basic structure element. So the collegium system continues.
Qualifications for an SC judge.
Citizen of India and either A, judge of a high court for 5 years, or B, advocate of a high court for 10 years, or C, distinguished jurist in the president's opinion.
Tenure and removal.
Hold office until age 65. Can resign or be removed. Removal is very difficult, only by an order of the president after an address by parliament, supported by a special majority, total membership majority plus 2/3 present and voting, in each house, on grounds of proved misbehavior or incapacity. It's a quasi-judicial process, often called impeachment, though the Constitution doesn't use that term for judges. No SC judge has been impeached so far.
Okay. Jurisdiction and powers. Original jurisdiction.
Deals with disputes between A, center and one or more states, B, center and states versus other states, C, two or more states. Exclusive original jurisdiction here. Also original jurisdiction, but not exclusive, for enforcement of fundamental rights, Article 32.
Appellate jurisdiction.
Here's appeals from high courts in constitutional, civil, and criminal matters. Also appeals by special leave, Article 136, from any court or tribunal, except military.
Advisory jurisdiction.
Under Article 143, President can seek the SC's opinion on any question of law or fact of public importance, or on pre-Constitution treaties agreements. Opinion is not binding on President.
Writ jurisdiction.
Under Article 32, can issue writs, habeas corpus, mandamus, etc., for enforcing fundamental rights. Its writ jurisdiction is narrower than high courts. Under R226, as HCs can issue writs for FRs and other legal rights.
Other powers.
Court of record. Judgments recorded for perpetual memory, power to punish for contempt. Power of judicial review, examining constitutionality of laws, executive orders. Decides disputes regarding election of President VP. Inquires into conduct of UPSC chairman members on president's reference.
Judicial review, that's fundamental.
Absolutely. Power to strike down loss orders if they violate the Constitution. Example, conflict with fundamental rights, outside legislative competence, violate basic structure. Grounded in several articles like 13, 32, 131, 136, 143, 226. The SC has evolved doctrines like severability, pith and substance, colorable legislation, and basic structure through its judicial review power.
Now, related concepts. Judicial activism and public interest litigation, PIL.
Judicial activism refers to a proactive role played by the judiciary in protecting citizens' rights and promoting justice, sometimes seen as departing from strict adherence to precedent or procedural norms, possibly entering policy domains.
Then
PIL is a key manifestation of judicial activism in India. It relaxed the traditional rule of locus standi, only the affected person can sue. Under PIL, any public-spirited citizen or social organization can approach the court, SC or HC, on behalf of victims or the public interest for enforcing rights or addressing public wrongs.
What kind of issues has PIL addressed?
A huge range. Bonded labor, under-trial prisoners, prison conditions, child labor, environmental pollution, consumer protection, corruption, election reforms, right to food, health. It has made justice more accessible for the disadvantaged.
But activism also faces criticism.
Yes. Concerns about judicial overreach, encroaching on legislature executive domains, separation of powers being blurred, courts getting involved in administration, potential for misuse of PIL, burdening the courts. It's a constant debate about the appropriate role and limits of the judiciary.
Okay, let's move down to the state level. State government starting with the governor.
Governor is the chief executive head of the state, appointed by the president, effectively by the center. Acts as head of state and also as an agent of the center. Has executive, legislative, financial, and judicial powers similar to president, but at state level.
Does the governor have discretionary powers?
Yes, quite significant ones, unlike the president who mostly acts on calm advice. Key discretionary powers include reserving a bill for president's consideration, Article 200, recommending president's rule, Article 356, acting as administrator of an adjoining UT, seeking information from the CM, and crucially, exercising judgment in appointing the chief minister if no party has clear majority, dismissing the council of ministers if it loses confidence and refuses to resign, and dissolving the state assembly. These powers have often been controversial.
Okay. The chief minister, PM.
Appointed by the governor, usually the leader of the majority party coalition in the state legislative assembly. Real executive authority at the state level.
Term. Functions.
Holds office during the pleasure of the governor. But this is linked to enjoying majority support in the assembly. No fixed term. Key functions. Heads the State Council of Ministers, advises governor on appointing other ministers, allocates portfolios, presides over state cabinet meetings, communicates decisions to governor, principal channel between governor and COM, leader of the House.
State legislature can be one house or two.
Yes. Most states have a unicameral legislature, just a legislative assembly or Vidhan Sabha. But some have a bicameral system, assembly plus a legislative council or Vidhan Parishad. Currently, 6 states have councils.
How is a council created or abolished?
Parliament can do this by law if the legislative assembly of the concerned state passes a resolution to that effect by a special majority, total membership majority plus 2/3 present and voting.
Assembly versus council composition and powers.
Assembly members are directly elected. Max 500, min 660. Exceptions exist. Council members are indirectly elected, 13 by MLAs, 13 by local bodies, 112 by graduates, 112 by teachers, and nominated by governor, 16th. Council is much smaller, max 30 of assembly strength, min 30. Assembly is far more powerful, especially regarding money bills. Council only has 14 days to consider, like Rajya Sabha. Council can only delay ordinary bills for max 4 months. Council is a permanent house like Rajya Sabha. Assembly term is 5 years unless dissolved earlier. Qualifications, disqualifications, presiding officers, Speaker Deputies, Speaker in Assembly, Chairman, Deputy Chairman in Council, legislative procedure are broadly similar to Parliament.
Okay. State judiciary high courts.
Constitution provides for a high court for each state, but Parliament can establish a common high court for 2 or more states, or UTs, example Punjab and Haryana HC, appointed by the President in consultation with CJI and Governor of the state and Chief Justice of the HC for other judges.
Tenure and security.
Hold office until age 62. Same removal process as SC judges. Very difficult. Service conditions fixed, expenses charged on state's consolidated fund, ensures independence.
Jurisdiction and powers.
Original jurisdiction in some matters, wills, marriage, company law, election disputes sometimes. Crucially, writ jurisdiction under Article 226, broader than SCs, covers FRs and other legal rights. Appellate jurisdiction, here's appeals from subordinate courts. Supervisory jurisdiction over all courts, tribunals in the state, except military. Control over subordinate judiciary, appointments, postings, promotions of district judges, etc., in consultation with the Governor State PSC. Court of record, power of judicial review, Article 226.
So very powerful courts at the state level. How many are there?
As of recent data, there are 25 high courts in India.
Below the high courts.
The subordinate judiciary. Hierarchy usually includes district and sessions judge courts, highest civil and criminal courts at district level, followed by courts of subordinate judges, munsifs, judicial magistrates, etc. Structure varies slightly by state, controlled administratively by the High Court.
Are there special courts or tribunals?
Yes. Parliament and state legislatures can establish tribunals for specific matters to reduce high court burden. Examples: administrative tribunals, CAT, Arts Center, SATs in states for service matters of government employees under Article 323A. Other tribunals for things like tax, land reforms, industrial disputes under Article 323B. Also, fast-track courts for specific cases like heinous crimes. Family courts under Family Courts Act 1984 emphasize conciliation. Graham Nihileus, village courts for speedy justice.
What about look-out-a-lots?
These are part of the Alternative Dispute Resolution, ADR system, organized by legal services authorities. They settle disputes through conciliation and compromise. Their award is deemed a decree of a civil court and is final, no appeal. Permanent look-out-a-lots exist for pre-litigation conciliation and public utility services.
And NLSA?
National Legal Services Authority, established under the Legal Services Authorities Act 1987, aims to provide free and competent legal aid to weaker sections and organized look-out-a-lots. State and district level authorities also exist.
We also hear about special provisions for some states under Article 371.
Yes, Articles 371 and 371A to 371J contain special provisions for 12 states: Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, Karnataka. These are aimed at meeting specific needs, protecting interests of backward regions or tribal populations, maintaining law and order, safeguarding local customs or economic interests. They override general provisions for these states in specific matters.
Okay, let's move to the grassroots local government, Panchayati Raj, first.
System of rural local self-government, given constitutional status and structure by the 73rd Amendment Act in 1992, added Part 9s, the Panchayats, and the 11th Schedule to the Constitution.
Key committees that led to this.
Balwant Rai Mehta Committee recommended 3-tier system, democratic decentralization. Ashok Mehta Committee suggested 2-tier system, revitalizing PROs. GVK Rao Committee, administrative arrangements. LM Singhvi Committee recommended constitutional status.
What did the 73rd Amendment mandate?
Key mandatory provisions include 3-tier system, Village, intermediate block, district level states below 2 million population can skip intermediate level. Direct elections for all seats at all levels. Reservation of seats for SCSTs in proportion to population. Reservation of not less than 1/3 seats for women, including SCST women seats. Fixed 5-year term. Elections within 6 months if dissolved early. Constitution of a state election commission to conduct panchayat elections. Constitution of a state finance commission every 5 years to review financial position and recommend devolution.
What about powers and functions?
The 11th schedule lists 29 functional items that state legislatures may devolve to panchayats, for example, agriculture, minor irrigation, rural housing, drinking water, roads, poverty alleviation, education, health, women and child development, PDS, welfare of weaker sections. The extent of devolution varies significantly across states.
What is the PISA Act?
The provisions of the Panchayats, Extension to Scheduled Areas Act, 1996, it extends Part 9X provisions to the 5th Schedule areas, tribal areas, with certain modifications to safeguard tribal rights, customs, and self-governance traditions, like mandatory consultation with Gram Sabha.
Okay, now urban local government municipalities.
Given constitutional status by the 74th Amendment Act, 1992, added Part 9S, the municipalities, and the 12th Schedule.
Types of urban local bodies?
Various types depending on size and nature of the urban area. Municipal corporation for large cities, municipal council for smaller cities, towns, Nagar Panchayat for transitional areas from rural to urban, also town area committees, semi-municipal, cantonment boards for civilian population in cantonment areas administered by Defense Ministry Center, townships for staff colonies of large public enterprises, port trusts.
Key features of the 74th Amendment.
Similar to 73rd, direct elections for seats, reservations for SCSTs and women, at least 13, fixed 5-year term, state election commission, state finance commission, same one reviews both panchayat and municipality finances. Also mandates constitution of district planning committees, DPCs, to consolidate plans prepared by panchayats and municipalities in the district, and metropolitan planning committees.
PCs.
For metropolitan areas, population over 1 million.
And function.
The 12th Schedule lists 18 functional items that state legislatures may devolve. Example, urban planning, regulation of land use, roads, bridges, water supply, public health, sanitation, slum improvement, urban poverty alleviation, parks, street lighting, regulation of slaughterhouses. Again, actual devolution varies.
You mentioned union territories earlier. How are they different?
UTs are directly administered by the central government, centrally administered territories, created for various reasons, political administrative considerations, Delhi, cultural distinctiveness, Puducherry, strategic importance, Andaman and Nicobar, special treatment for backward tribal people, Mizoram, Arunachal initially, now states.
How many are there now?
Currently 8 union territories.
Who administers them?
The president, acting through an administrator appointed by him, designated as lieutenant governor, chief commissioner, or administrator. Parliament can make laws on any subject, including stateless subjects, for UTs.
Do any UTs have legislatures?
Yes. Parliament can create a legislature and/or council of ministers for certain UTs, Article 239A. Puducherry and Delhi currently have legislatures and COMs. Jammu and Kashmir UT also has provisions for one. Article 239AA provides special provisions for Delhi, National Capital Territory, giving its assembly power over state concurrent list subjects except public order, police, and land.
What about scheduled and tribal areas?
The Constitution has special provisions for administering these areas to protect tribal interests. The 5th Schedule applies to administration of scheduled areas and scheduled tribes in states other than Assam, Meghalaya, Tripura, Mizoram. The 6th Schedule applies to administration of tribal areas in those 4 specific states.
Key features.
5th Schedule. Governor has special responsibilities, submits a report to President. Tribes advisory councils to be set up. Governor can direct that acts of Parliament state legislature don't apply or apply with modifications. 6th Schedule. Provides for autonomous districts and autonomous regions, with district councils and regional councils having legislative, executive, and judicial powers over certain matters to protect tribal autonomy. Governor has certain discretionary powers here, too.
Okay, nearly there. Let's quickly touch upon some key constitutional and non-constitutional bodies. Election Commission.
Article 324. Independent body, responsible for conducting free and fair elections to Parliament, state legislatures, President, and Vice President. Prepares electoral rolls, delimits constituencies, recognizes parties, allots symbols, enforces model code of conduct, comprises Chief Election Commissioner, CEC, and other election commissioners, currently 2. CEC has security of tenure like SC Judge, others removable on CEC's recommendation.
Union Public Service Commission, UPSC.
Article 315323. Central Recruiting Agency. Conducts exams for all India services, central services. Advises government on promotion disciplinary matters. Chairman and members appointed by President have security of tenure. Removable only like SC judge for misbehavior after SC inquiry. Its role is advisory, recommendations not binding. State Public Service Commissions, SPSCs, perform similar functions at state level.
Finance Commission.
Article 280, constituted every 5 years by President. Recommends distribution of net tax proceeds between center and states, principles for grants and aid, measures to augment state consolidated funds for panchayats municipalities. Recommendations are advisory but generally accepted. Acts as balancing wheel of fiscal federalism.
National Commission for Scheduled Castes.
Article 338. Investigates and monitors safeguards for SCs, inquires into specific complaints, participates in planning process for socioeconomic development of SCs, reports to President, has powers of a civil court. Similar National Commission for Scheduled Tribes, NCST R338A, and National Commission for Backward Classes, NCBC R338B, given constitutional status recently, exist.
Controller and Auditor General of India, SAG.
Article 148. Independent authority, head of Indian Audit and Accounts Department. Audits all receipts and expenditure of union and state governments, government companies, other bodies financed by government. Acts as guardian of public purse, ensures financial accountability. Appointed by President, security of tenure like SC judge. Submits audit reports to President governors which are examined by public accounts committees.
Now, key non-constitutional bodies. Attorney General of India.
Article 76. Highest law officer of the country. Appointed by President, must be qualified to be SC judge. Advises government of India on legal matters, performs other legal duties assigned by President, has right of audience in all courts, right to speak in Parliament, but not vote, holds office during pleasure of President. Similar Advocate General for states under Article 165.
NITI Aayog.
Replaced the Planning Commission in 2015. National Institution for Transforming India. Serves as the government's premier policy think tank. Aims to foster cooperative federalism, develop mechanisms for village-level planning, monitor programs, provide strategic advice. Headed by PM, Governing Council includes all CMs and LDs of UTs.
National Development Council.
NDC. Apex body for decision-making on development matters, presided over by PM, includes union cabinet ministers, CMs, administrators of UTs, members of Planning Commission, now NITI Aayog. Set up by executive resolution. Role has diminished somewhat within NITI Aayog, but formally still exists to approve 5-year plans, though those are discontinued, and review national plan working. Promote center-state coordination and planning.
Wow. Okay, that was an incredibly comprehensive run-through. We covered a massive amount of ground from Lax McKent's work.
We certainly did, from the historical roots right through the structures, principles, rights, duties, institutions. It's a complex system.
So pulling it all together, what's the big picture takeaway?
I think it's that complex interplay we talked about. History shaping principles, principles shaping institutions, and the constant dynamic between center and states, between rights and duties, between flexibility and rigidity. It's a living, evolving framework.
What stands out to you as maybe surprising or particularly fascinating?
For me, it's perhaps the resilience and adaptability. Despite the immense diversity and challenges, this constitutional framework, with all its intricacies and sometimes contradictions, has largely held together and evolved, often through judicial interpretation, to meet new needs. That basic structure doctrine, for instance, is a remarkable judicial innovation.
It really is a unique system, isn't it? That blend of federal and unitary, the specific solutions crafted for Indian problems. So, listening to all this, what should someone be thinking about Indian polity?
Well, hopefully this deep dive gives a solid foundation, a structured way to think about it, without getting completely lost in the weeds. It shows how interconnected everything is.
Absolutely. So, here's a final thought to leave everyone with. Considering that ongoing tension, that balance between a strong center and autonomous states, what do you think is the biggest challenge facing Indian federalism today?
That's a great question. Or perhaps, thinking about the basic structure doctrine, how might that continue to evolve and shape India's constitutional future, especially as society and politics keep changing?
Lots to ponder there. We really hope this deep dive has been valuable. Let us know if you have follow-up questions or other areas you'd like us to explore in the future.